Yes, thank you, Jacques. Welcome to all of you. Um, well, a few words of introduction about the questions we discussed amongst ourselves when we were wondering how to find a way to speak about this Kabab-Ji Kout Food case from the perspectives of our three jurisdictions. For UK and France, it's quite easy. As you know, 10 years after the Dada case in Kout Food, we had an interesting example of how English courts and French courts could reach really the most opposite solutions to all the questions which were raised in one particular case. And we discussed with our Luxembourg friends whether in their courts we would have a solution which would be more close to the French one or the English one, and it's not an easy question to answer to. So the questions we had in mind were, okay, if you are a company in an arbitration with a parent company or a sister company in Luxembourg, France, or England, can these companies be attractive to your proceedings? Will the award be enforceable in the jurisdiction where the company is located? And the answer will depend on two questions, on two main criteria, which are the seat of the arbitration, but also the place of enforcement, of course. So I will maybe start with a short presentation of the case for those who do not know it already. In 2001, a Lebanese company, Kabab-Ji, entered into a 10-year franchise development agreement with Arbitration, a Kuwaiti company, for the development of the Kabab-Ji brand in Kuwait. This initial franchise development agreement was followed by several agreements, 10 in total. And all these agreements contained clauses providing for English law governing the agreements and ICC arbitration in Paris in case of dispute. In 2005, and the Arbitration Group was reorganized, and there was the creation of the Kout Food Group company, which became the parent company of Arbitration, and started performing the agreements, or at least interfering a lot with the performance of these agreements with the company Kabab-Ji. So this is the factual background of the case. In 2011, the agreements expired, and in 2015, Kabab-Ji filed a request for arbitration. And just to save time, I will go quickly on the facts. But the request for arbitration was directed against Kout Food Group, the parent company of the other party. And Kabab-Ji alleged that Kout Food Group was the one performing the agreements, was the one terminating the dealings, and that it has failed to fulfill its obligations under the franchise agreements. Of course, Kout Food challenged both the jurisdiction of the arbitral tribunal and the merits of the claim, saying that it was not a signatory party to the agreements, and therefore it was not bound by the arbitration clause nor by the substantive obligations of the contracts. The award was rendered in 2017, and then in this award, the arbitral tribunal had to answer to two questions. Well, the first one was the jurisdiction over Kout Food, and a threshold issue was to determine which law the arbitral tribunal had to apply to determine its jurisdiction over Kout Food. And the arbitral tribunal applied French law as the law of the seat, ICC arbitration in Paris, to determine whether the arbitration agreement was binding Kout Food or not. And then, on the merits, the arbitral tribunal applied the governing law clause of the agreements, applied English law, and decided that under English law, Kout Food had become a party to the agreements by way of novation, and awarded Kabab-Ji $7 million. After that, the award gave rise to several proceedings. As you can see, I will not go into the details, but in England, the English courts decided the award could not be enforced because it has been rendered against what they considered to be a non-party to the arbitration agreement. And in France, the setting aside proceedings filed against the award were rejected by the Paris Court of Appeal, approved by the Cour de cassation, on the ground that the arbitral tribunal has rightly upheld jurisdiction over Kout Food. So we have very opposite decisions from English courts and French courts, with something which cannot be satisfactory, because you have a situation where the law of the state says, okay, the arbitration award is fine, and we agree with the decision of the arbitral tribunal of jurisdiction. And then for the enforcement, you have the English courts which say, no, the arbitral tribunal is wrong, it didn't have jurisdiction, we will not enforce against Kout Food. So why? Because these two different set of courts did not choose the same applicable law to answer the same question. And this leads us, I think, to the core of the conference.
Thank you very much, Marilyn. So our speakers will share their views from their respective jurisdictions on two questions. Firstly, the determination of applicable to the arbitral agreement, and secondly, the extension of an arbitration agreement to a third party. So perhaps, Marilyn, could you reverse the view from Luxembourg?
Just before we get there, we wanted to reread with everyone the provisions of Article 518 of the New York Convention, as it gives some indication when it comes to recognition and enforcement of the award, because it may be refused if the agreement is not valid under the law to which the parties have subjected it, or failing any indication thereon under the law of the country where the award was made. And while preparing this conference, Marie-Hélène identified a comparative study from which it results that actually there is no uniform interpretation of this clause. There are very, very various interpretations. So this leads to our subjects.
Thank you very much, Lauren, and thank you very much, everyone, for coming. So we decided to start with the English law position. I won't say it's the most complicated, but it's certainly the most detailed. And to understand the English law position at Kout Food, we do need to take a step back and look at the 2020 Supreme Court case of Anchor and Shell. Because before Anchor, there was some uncertainty as to how English law would consider this question of the applicable law to the arbitration clause. So in Anchor, the Supreme Court really went into detail and took a step-by-step approach to analysing what law should apply to the arbitration clause of the law judgment. It's 140 pages. It also wasn't a unanimous judgment. There were two members of the court that disagreed with it. That was on a very narrow point, insofar as the principles that are applicable to Kabab-Ji. In fact, all 5 members of the court were in agreement. So just to set the scene for Anchor, the issue was slightly different from Kabab-Ji, because in that case, there was an application for an anti-suit injunction. So the court had to consider the law applicable to the arbitration clause from a perspective before the award was issued. That means that, strictly speaking, the Article 5.1a of the New York Convention that was mentioned by Marie-Hélène wasn't, strictly speaking, applicable. But nevertheless, the court thought that it would be illogical to apply a different approach before and after an award was issued. So those provisions were influential. So in a nutshell, in Anchor, the English court's approach was as follows. First of all, the English court started off with English law. Why? Well, because England is the forum you have to start with. But then they noted that English law adopts a conflict of law approach. In that case, because it's a question of a law applicable to the arbitration clause. The court answered that Rome 1, the Rome 1 regulation and how it's retained EU equivalent does not apply because there's a specific exclusion that provides that it doesn't apply to arbitration clauses. And so as a result, the court simply had to look at the common law position. And the common law position provides that the applicable law is either the law expressly or impliedly chosen by the parties, or in the absence of a choice, at the law that is most closely connected to the contract. So how does that pan out in a situation where you're looking at the arbitration clause itself? Well, the court noted that there were essentially three scenarios. Scenario number one, as I said out of the slides, if the party has expressly chosen a law that is specifically applicable to the arbitration clause, well, there it's simple. The court will simply apply that law. But for Anchor, there were very few examples where the parties would actually apply a law specifically to the arbitration clause. Since all the debate around Anchor, I have actually seen a few of them. I think it's nevertheless going to remain rare. So that brings us on to the second scenario. What if the parties have chosen a law to apply to the contract as a whole, not specifically to the arbitration clause? Well, in that circumstance, the English courts are required to construe the contract, essentially. So they look at what they think the intentions of the parties, subjectively speaking, must have been. And the Supreme Court considered that in general, not always, but generally, if parties decide to apply a law to the whole of their contract, they mean the whole of the contract, so they need the arbitration clause as well. So the bottom line is that choosing a seat of arbitration is not going to displace, as a general principle, the idea that the law applicable to the arbitration clause is the law that the parties have chosen to apply to the contract as a whole. And that can be an express choice, it can also be an implied choice. So that's the general principle. As I've said on the slides, there are some exceptions to that. And in particular, there are two circumstances where the courts enter the parties are likely to have had a different intention as to what law applied. First is what's known as the validation principle. And that's simply the idea that commercial parties to a contract are unlikely to have chosen a governing law for their arbitration clause if that governing law would make the arbitration clause ineffective. So the example that was cited by the court is the South America case. In that case, it was a Brazilian law governed insurance contract. But under Brazilian law, there was a possibility that the arbitration clause would not be valid unless the insured party specifically accepted it. So in that case, the court held that the parties couldn't possibly have intended a Brazilian law to apply, so they looked to the law of the seat, which in that case was English law. So that's the first exception. The second exception is in cases where the law of the seat expressly provides that an arbitration agreement will be governed by that law of the seat. And in that case, we could get two examples, the Swedish Arbitration Act and the Scottish Arbitration Act, both make provision that the law of the seat will govern. This is in fact likely to be quite a significant exception. You referred to the Sharon Jensen study. That study, I think, suggests that at the moment, past national laws have not been too specific about governing law. But given all the debate around Anchor and Kabab-Ji, the issue is now a more important one. One can ask, well, what exactly is that? And what impact is that going to have on English law when national laws start being more specific and perhaps more national laws start providing that the law of the seat is going to be the governing law for the arbitration clause? What's that going to do? to the English court's view in terms of the parties' intentions in that regard. So those are the two exceptions to the principle set out in ENCA. But to summarise, absent those exceptions, the court will usually find that if the parties chosen a law to apply to their contract, the same law would apply to the arbitration clause. And just for completeness, in ENCA there was a third situation governed considered, and that is the situation where the parties haven't chosen a governing law for their contract at all, and no governing law can even be implied. Funnily enough, in ENCA itself, that was the situation. It was a contract of some 500 pages. Nevertheless, the parties had chosen not to include the governing law clause. And there was no, the majority of the Supreme Court found that there was no implied law either. And in that situation, only the court will look at the closest connection to the arbitration clause. And it's generally, although perhaps not always, the country with the closest connection to the arbitration clause is going to be the country of the seat. So in that situation, only English law tends to look at the law of the seat as the governing law of the arbitration clause. That was a rather long introduction to Kabab-Ji. It was necessary, but because Kabab-Ji, although the Court of Appeal decision took place before the Supreme Court decision in ENCA, by the time Kabab-Ji got to the Supreme Court in the UK, and had been decided. And so essentially, the Supreme Court in Kabab-Ji adopted the principle of an ENCA, and they seem to find it essentially quite simple to come to an answer on that basis. I should nevertheless underline that it wasn't exactly the same situation, because as I mentioned in ENCA, it was an application for an anti-suit injunction, so determination before an award had been issued. In Kabab-Ji, as Marianne mentioned, the question was whether or not to enforce an arbitration award. So as a result, Article 5.1a of the New York Convention, in its incarnation as imported into English arbitration law in the Arbitration Act, directly applied to it. And so as a result, the court was looking at, well, what is the law that the parties subjected the arbitration clause to, or plain in black, the law of the country where the award was made. So in the Kabab-Ji case, the court noted that there was a governing law clause for agreement as a whole, which said that the agreement shall be governed by and construed in accordance with the laws of England. And that, for the court, was sufficient to amount to an express choice of law for the contract, but also an express choice of law for the arbitration clause itself. So simple in a way. I think from a comparative law perspective, there are 2 points that were interesting, that were unsuccessfully raised on behalf of Kabab-Ji. The first is that in the arbitration clause itself, there was an additional sentence that said that the arbitrators should also apply principles of law generally recognized in international transactions. And the parties essentially accepted that that was a reference to the unitoire principles. Kabab-Ji essentially attempted to argue that this would somehow displace the choice of English law. The decision of the court on that point was very flat. English law regards the governing law of a contract as a national law only. So as a result, the only law that was applicable was English law. Unitoire principles could be applied in addition, but they weren't a governing law of the arbitration clause. The second interesting point, Kabab-Ji also sought to rely on the validation principle that I mentioned earlier. Essentially, that a court will find the parties are unlikely to have agreed on a law that makes their arbitration clause invalid. Interestingly, though, the court found this principle doesn't apply in the context of an extension of an arbitration clause, and isn't a principle in favour of extension of an arbitration clause it only applies when you're looking at whether to uphold the validity of an existing arbitration clause between its existing parties, and not when you're looking at whether or not to extend that clause to a third party. So, in summary, the position of the Supreme Court was that under English law applied to the arbitration clause, and as a result, there was no prospect of Kout Food being a party to the clause. So just in conclusion, it's important to know what the court was and wasn't saying by that. They were not at all saying that the law of the seat was irrelevant. The law of the seat remains the law that applies to the arbitration process. The courts of the seat retain a supervisory and supporting jurisdiction. And in particular, in England, that includes perhaps the power to grant an anti-suit injunction in appropriate cases. But nevertheless, in terms of the extension or the validity or the interpretation of the arbitration clause, that was English law in this case.
Thank you very much, Natasha. It was very interesting for a continental lawyer as myself to have this full description, complete description of the approach taken by English courts. Perhaps, Maïren, you could explain to us what is the French approach?
Yes. Why the proceedings were ongoing in England, Kout Food Group filed an application before the Paris Court of Appeal to have the award set aside. And the argument raised by Kout Food was exactly the same as the one they successfully opposed in England, which was that the parties had expressly chosen the English law to govern the scope and validity of the arbitration agreement, and that under English law, this agreement could not apply to Kout Food. By contrast, Kabab-Ji supported the tribunal's decision to apply the law of the seat, which was France. French courts rejected, as you know, Kout Food's arguments, considering, and that's interesting given what you have just heard, considering that there had been no explicit choice of English law to govern specifically the arbitration agreements. And then, and this is where I think both courts differ the most, then French courts followed an entirely different approach to determine which law governed the arbitration agreement in the absence of such an express choice. The first, this approach is what we call the material law, substantive rules approach, which did not carry out any conflicts of law reasoning, but just applied substantive rules of international arbitration law as developed by French courts since a few years. Well, more than that. The first rule is that is a rule according to which the arbitration clause is fully autonomous or independent from the underlying contract, and therefore its existence, its validity, its efficiency depend only on the common intention of the parties, without it being necessary to make reference to any national law. And the second rule which was applied after that was that the validity and efficiency of the arbitration agreement itself commands to extend it and extend its effects to the parties directly involved in the performance of the contract, and so on. I'm summarizing. So first, the first rule, which is that we do not need to refer to any specific domestic rule of law when determining the validity and effects of an arbitration clause, is based on the principle of autonomy or severability, but it's more than that under French law, severability and autonomy of the arbitration clause from the underlying contract. I will go a bit quickly because I try to be on time, but this is something our French friends here know very well. As you can see, it's based on rulings from 1963, so it's not a recent solution, it's not something new. The first decision here, Gosser in 1963, it is famous because it's for the first time, it ruled that the arbitration clause was severable from the underlying contract, and therefore, if the contract was void and null, this would not affect the arbitration clause itself. And this is something on which I think our English friends would agree to. But then we went further and we developed this principle, and in Hecht versus Prisman in 1972, the court decided that the arbitration clause may be governed by a law different from the one of the main contract. Well, this is also something our English friends would agree to. And then there was the Delico case, and a lot of cases since Delico, in which you can see on the screen the developed version of what I summarized a few minutes ago. And the rule established in the Delico case is that according to a substantive rule of international arbitration law, something international, but developed by French courts, actually, the arbitration clause is independent from the main contract, and provided that no mandatory provision of French law in the national public policy is affected, its existence and its efficiency depend only on the common intention of the parties without reference to national law. So what I was quoting was the Delico case, and this principle has been standing since, and it's applied in our case. Why this rule? Because actually it's the French court saying there is an international principle of international law we are establishing, and based on this principle of international law, we do not need to go see what other jurisdictions have to say about the validity of arbitration abroad. It's quite strong. I mean, it's not something you will find in every jurisdiction. But the idea is that French arbitration law is very much in favor of arbitration, and the idea is to ensure the effectiveness of the parties' will to go to arbitration and avoid technical arguments or corporate arrangements which would go in the way of the efficiency of the initial agreement to go to arbitration should any dispute arise from the contract. I think it's the basis of this. And for instance, in this Kout Food case, Kout Food tried to there was an agreement based on the local laws and the capacity and power of the representatives who signed the arbitration clause. That sort of arguments that do not fly before French courts. We just go and see whether the parties agreed to have all disputes coming from the contract submitted to arbitration. So we don't look at corporate law or anything like that to sum it up. And when I say that we just apply this substantive rule to determine the validity and the effects of the arbitration clause in French court, does it mean that we are applying the law of the seat? Because French courts were the law of the seat, and as I said in the Kout Food case, the arbitral tribunal applied this substantive rule, the Delico rule, because it was the law of the seat. But I'll repeat it. Well, in a way, yes, if you are the arbitrator, seated in Paris, then your reasoning will be, okay, if my award is not valid under French law, it will be set aside, so I apply French law because it's the law of the seat, and in French law, under French law, we have this substantive rule, I apply it. But it's not, strictly speaking, the lesson we should learn from this case, because if really French courts were saying, well, the arbitration agreement is governed by the law of the seat, they would not apply the Delico rule when they are, for instance, hearing a case about the enforcement of an award seated in London. Just let's imagine 1 minute that in Kout Food, the seat of arbitration would be London. And then French courts would have heard the case because one of the parties would have tried to enforce it in France. Would they apply English law? No. No, they would have applied the Delico rule, and they would have examined the jurisdiction of the arbitral tribunal sitting in London only based on this rule, based on the principle of validity and the content of the parties' will and common intent. So French courts are not applying the law of the seat, which made vary depending on the seat. Every time French courts have to rule about the enforceability of an arbitral award seated anywhere in the world, they will apply the same rule to determine what rules apply to the validity and effect of the arbitration award. I thought it's clear because some commentators may have sometimes be a bit misled by the wording of the ruling of the Vice Court of Appeal referring to the law of the seat. But basically, it's a substantive rule and there is no conflicts of law approach at all before French courts. I will go quickly because I think time is, yes, and stay comfortable. Okay, good. There is an exception though, and it wasn't that clear before the Kout Food case. Now it's clear. The Court of Appeal and the French Cour de cassation, the Supreme Court, affirmed that there is an exception to this application of substantive rules, and this exception is when the parties have decided otherwise. Very expressly. The parties may choose a law, a domestic law, applicable to the arbitration agreement, to its validity, to its effects. The cornerstone is always the parties' will. But this choice must be very, very unequivocal. You may remember that Natasha brilliantly went step by step into the reasoning of the English court, and for the English court, there was such an express choice of law in this case, because the parties referred to the agreements, defined capitalized term, and in the agreements, specific provisions were referred to, amongst which the arbitration agreement. And the agreements, as defined, were supposed to be governed by English law. So there was a whole argument by Kout Food Group in this case, well, just look at the definition of the word and the capitalized terms. There is an express choice to govern the arbitration agreement and to have it governed by English law. But the French courts decided otherwise, and decided that while it was not unequivocal, it was a wide definition, large definition of the agreements. There have been several agreements in this case, and this general reference to English law as governing everything, all these agreements was not specifically enough to establish an equivocal commonwealth to submit the arbitration agreement to English law. And then the courts noted the reference in the arbitration provision of the reference to the general principles of transnational commercial law, which was construed by English courts as a reference to the unit law principles, amongst others. And the court said, well, just look at that. International principles of arbitration law may apply. So, well, which provision should prevail? Well, we don't know. So we applied the substantive rules of international arbitration as we know them in the French law. So when I say that the provision by the parties must be very, very unequivocal, you have to drive to provisions very specifically if you do not want these general rules to apply. Of course, there is an obvious limit to this, and I think it's my conclusion, because as Natasha said, well, before the ENCA case in England, I think I haven't seen any clause really specifically providing for the law applicable to the validity and scope of the arbitration agreements. Since then, there have been a few. I think some of these clauses may not pass the test of the English court. So you have to very specifically that you want your arbitration agreement, its validity, its effects to be governed by, and though you wish, if you do not want it to be governed by the material rules of French law when it comes before the French courts.
Thank you, Maïden. Well, I'm afraid there is a clear gap between UK and France. Maïden, what would be the approach by Luxembourg courts?
So I'm actually very excited to exchange on this subject today, because last week we adopted a new law in Luxembourg, which gives new perspectives and changes completely the landscape. So we're kind of on an unknown territory for the moment. What we know now in terms of what the law provides is same thing as what was previously mentioned. If the parties chose the applicable rules, then the arbitrators will apply this. Fine. But what happens if they did not? So, contrary to French court decisions, which have been for a long time now very clear on the autonomy of the arbitration clause, we had a decision in 2002 by the Court of Appeal which considered that there was actually no autonomy of the arbitration clause. In 2005, there was a decision which was handed down which seemed to go the opposite way, but it was still unclear. We had to wait until 2016, and this is only the district court, where it seemed that there was an opening to the autonomy of the arbitration clause. We now have a clear new law, which at least confirms that this is the case, because it clearly says that the arbitration clause is a separate agreement from the other terms of the contract. So now I think we are clearly aligned on the French position in that respect, and we do have an autonomy of the arbitration clause. So with this in mind, the question is, fine, now how does it work to know which law will apply? Well, again, here it's the arbitral tribunal which will decide. Unfortunately, our legislator did not hear you, Natasha, when you said that new laws should take in consideration maybe how this would work and maybe already indicate that it should be the place of the seats that's for the rules to apply. Here, it really is up to the courts to appreciate, or up to the arbitral tribunal to appreciate which law it will apply. How so? Well, I would tend to say what was said earlier on by looking at the choice of law for the whole contract, which can be a clear indicator, or by applying private international law, which can be helpful. So this is kind of the basis where we stand today. When we discovered, Fabio and I, this decision and discussed with our colleagues on this matter, initially, we clearly thought that Luxembourg courts, if they were to hear such a case, would go towards the reasoning of the English courts. Now, with this new law, with the evolution of case law, I'm not quite sure of that. There is clearly no certainty, but maybe also an opening towards the French position. So, unfortunately, I cannot tell you today who will go on one side or the other. I think both are possible, and it will be interesting to see what happens in the future.
Thank you very much, Ryden. Now that we know which law to apply, how, if we can, shall we extend the arbitration provision? Marie-Hélène, may I give you the mic?
Yes, thank you. Well, as if you say, extend it or not, finally we come to the subject of this conference. We can already jump to the conclusion. You'll find that the differences are very, very different depending on the seat and place of enforcement, but I think this is something you understood from the beginning. So the French perspective on extension, we started with the French perspective because it's mostly presented as a French invention, this extension of arbitration clauses to what some people call third parties and what I would call non-signatories of the clauses. So what is extension under French law? Is it something really dreadful where every parent company or sister company can be attracted to the proceedings targeting their subsidiaries? No. I mean, French law knows about the principle of privity of contracts. We know the concept of corporate veil, but sometimes, under some circumstances, we consider that it can be pierced this way. I will not go into the details of the very rich case we have on the subject, but I will try to lead us just within the few principles which, in my opinion, support and explain the case that we had in France, which is an evolving one. Just a few basics. We are only considering here the hypothesis where there has been no formal assignment of the substantive rights and obligations under the particular contract containing the arbitration clause and to another entity. And so this entity is formally a third party to the contract. But nevertheless, this third party has been very much involved in the life of the contract. And when a dispute arises on this contract, well, the other party attempts to hold them liable and to attack them in the arbitration proceedings they started based on the dispute resolution clause of the same contract I was speaking of. And there is the two-step reasoning at this stage. First, the arbitral tribunal has to determine whether this party can be attracted in the proceedings, and then, and only then, they will have to determine whether this non-signatory party is liable or is bound by the substantive rights and obligations of the contract. But it's a two-step reasoning. If you are considered bound by the arbitration clause, it doesn't mean you are liable in the end. Two steps. And in the Kout Food case, it's very interesting because the arbitral tribunal did this two-step reasoning very, very clearly. So the question here, when you are speaking of extension of the arbitration clause, is whether this party will go before the arbitral tribunal so that the same arbitral tribunal will decide amongst all the entities concerned in the proceedings which are the respective liabilities of and who is bound, who is not bound by the contract. But at least we do not have multiple proceedings in different forums to decide all that. We have one proceedings before the arbitral tribunal. So, the key notions, I put some of them on the slide. Well, consent. Sometimes I read interesting things saying that, well, when it comes to extending the clause, French court seems to have forgotten that consent is the cornerstone of arbitration, and that to be attracted to arbitration proceedings, you're supposed to have accepted the arbitration clause in the first place. No, we haven't forgotten that, but there are a lot of considerations which explain that we may have a different view on this consent, a different view from other jurisdictions. One of the principles developed by French courts is the validity and efficiency of the clause. And of course, there is always this idea to avoid having artificially multiple disputes to decide one same issue in one same economic transaction and one same contractual transaction. And then there is also the principle of good faith. You know how French law loves good faith, and we apply it, there is a particular scrutiny put on the behavior of the parties, and especially the non-signatory. First, maybe, I should just leave aside the issue of the fraud, which under many jurisdictions would allow the courts to pierce the corporate veil when there is an absolute abuse of the difference between corporate entities. So you pierce the veil, but this is something I think which is shared in other jurisdictions. What is more specific to French law is the extension of the efficiency of the clause to parent companies, subsidiaries involved concretely in the performance of the contract or in the negotiation, in the execution, in the termination of the contract. One slide. As you can see, there's a lot of case law. I did not put everything, just a few names. It started with the chemical, but then we've had an extensive case law. The common ground in every case, I've mentioned on the side and loads of cases actually, is that the focus is not of the very existence of a group of companies, but on the involvement of the parent or sister companies, the third party, the alleged third party, in the negotiation, execution, performance of the agreement. We may discuss that later because we don't have much time to go into the specific examples, but one issue which has been very much discussed is whether we have to characterize consent by the party who was involved in the performance of the contract or its termination or even the dispute you can be involved, and you can become involved at every stage of the relationship, and it may expose you to being attracted to the arbitration proceedings, depending on this involvement. But does the claimant need to show that you knew about the arbitration clause, at least, and even that you accepted it? And all this, I could have given a clear answer, I think, a few years ago. I'm not sure I can now, because with the ABS case, the Cour de Cassation approved all the case law built by the Paris Court of Appeal on this objective criterion of the involvement of the third party, saying, okay, you can extend an arbitration clause when there is such strong involvement of the third party. And the Cour de Cassation did not make any reference to implied consent, implied ratification of the contract or the arbitration clause, or implied knowledge of the arbitration clause. No reference at all. So starting from the ABS case, commentators and lots of people started to think, okay, this is a purely objective test. You have to show involvement, and even if the party did not even know about the arbitration clause, it can be extended. When I have a look at the recent case law of the Paris Court of Appeal and at the Kout Food case, it's not exactly what is written by the court. The court refers to the involvement of the parent company with formula which had not very much changed since years, but also always specifies that this involvement, this behavior, leads to infer or to presume that there was at least a knowledge and even an implied consent to the arbitration clause. So consent is still there, implied, but there. It may seem a bit, well, if it's implied, is it really there? Yes, because it means that you could decide over what you could specify that you do not want to be bound by the arbitration clause. You could take some steps to avoid the extension of the arbitration clause. When you have the parent company or sister company and you start taking over the obligations and duties of your subsidiary in a contractual relationship where there is an arbitration agreement with the sitting funds, for instance, well, maybe you can just be very clear about your role and your legal status in the contractual relationship. You can say, I am only acting as a representative, and clearly, I am not bound by the arbitration clause. And if things are clear, well, it may seem a bit theoretical, but at least the door is open to a demonstration of a party's will not to be bound. And that's interesting. It's not a purely objective test, in my opinion.
Thank you, Mayeden. Heddersham, I'm very curious to know whether English courts share this approach.
Well, yes, I think I can give a very simple answer to that, but that isn't fair. Traditionally, the English courts have been very conservative. On the question of extension of an arbitration clause. The basic position is that just because a party has participated in the negotiation of the performance or the termination of a contract, that does not mean that you can extend the arbitration clause to them. I think in reality the position that is a little bit nuanced, and that's because essentially an arbitration clause is part of a contract. Derivative contract, of course, applies. But as you said, Marianne, the question is, because one of consent, and under English law as well, the question is, will the parties be deemed to agreed to extend either the contract itself or the arbitration clause to a third party non-signatory? I think often the English law is going to come to a very different answer, and the Kabab-Ji and Kout Food's case is actually very interesting as far as this is concerned. Because in Kabab-Ji, there was actually an argument that the contract had been novated to Kout Foods. And you may remember from the summary the arbitral tribunal itself actually found that there had been an innovation of the contract to Kout Foods. Now, if that was the case, that would be sufficient in principle under English law to transfer not only the contract but also its arbitration clause. So there are situations under English law where it's possible to transfer the arbitration clause to third parties. It's just that in Kout Foods itself, the Supreme Court, although it wasn't entitled to look at the merits of the decision that the arbitral tribunal reached, nevertheless considered this question of had there been an innovation from the point of view of looking at was this sufficient to establish jurisdiction because the arbitral clause had been transferred. And looking at that under English law in the circumstances of that case, the answer was very clearly no. Why? Because there was in the contract itself an overall modification clause, and Kabab-Ji did not show that things that happened to ground perhaps an estoppel or somebody else it would allow to get around this new oral modification clause. So despite the fact that Kout Foods have become involved in the contract as a matter of English law, the arbitration clause had not been extended, and that's the general principle. The courts will look at the contract, they'll apply the usual principles of English contract law to determine whether or not a third party is bound. And so I would on to what those are. I've mentioned innovation. There's also the possibility of an assignment, if contract rights are assigned. The assignee will not be bound by an arbitration clause in the original contract. Subrogation, insurance context, contracts rights of third parties act. So there are a number of technical ways in which a non-signatory can become bound by an arbitration clause. There's also the very simple and pragmatic situation of, well, if you bring an arbitration against a third party, that third party doesn't raise jurisdictional objections, well, in general circumstances, that will mean that the third party is accepted to jurisdiction, and they'll therefore become a party to the arbitration and be bound by the arbitration clause. So English law does allow transmission of the clause to third parties in certain circumstances. But I think in conclusion, it's interesting to go back to what Maryland was started with in opening, and that's the case of Dalla in Pakistan. It's in a sense it's of anecdotal value, because in that case, English Supreme Court was required to decide whether or not an arbitration agreement had been extended to the state of Pakistan as a matter of French law, because French law was the government law in that case. And the English Supreme Court, applying French law, found that the extension had not happened. Subsequently, the matter went before the Paris Court of Appeal that also applied French law, and the Paris Court of Appeal found that under French law an extension had happened, and so Pakistan was bound by the clause. And I think what that shows is just the difference in legal instincts, if you like, in England and France. England is very resistant to this idea of extending the clause.
I get it, Michelle. How about Luxembourg, Fabio? Thank you, Zach. Well, Luxembourg, as usual, there's less to say, there's less case law, smaller country. What I want to answer to, there's two questions. First of all, can a parent sister company be attracted? And then the enforcement against a non-signatory. So the short answer, as Lauren said in the beginning, and that's the answer we had in mind when we start working on it, is no. If you did not sign, consent is key. So there's no consent, there's no arbitration, you cannot do that. Well, it's not as simple. First of all, let's go to, of course, Article 1165 of the Civil Code. We recognize, as in France, the privity of contracts. And in this sense, we are very close to Belgium as well. But there are exceptions, and there is one decision which we found 2012, which was actually the case we had. And in this situation, the court looked into what happens, how the parties behaved, and it found that it resulted from the participation in information or in the performance. And it looked into that, and it found that there was a contractual basis, there was consent, because it was applied. And so, in one circumstance, and it's not a court of appeal decision; it's a district court decision, which was not challenged. So, in one situation, the Luxembourg court admitted that it can be extended to a party who clearly showed consent. Other situations which we can briefly touch upon is, of course, the assignment of a contract or a stipulation for the benefit of a third party. That's Article 21, simple application of our law. There might be exceptional circumstances, very, very seldom used in Luxembourg. The fraud must be serious, because in order to pierce the corporate veil of the Luxembourg company, it's very tough. It could happen, so in this situation, why not? There is a decision in bankruptcy, in a situation of bankruptcy, where the bankruptcy trustee was challenging the arbitration clause. Court said, no, you're bound. And the latest finding that we want to mention is that the group of company doctrine, which is very French, is not recognized by Luxembourg Case Law so far. So how about the enforcement of the award against a non-signatory? Well, except for the fact, as Ronan said, that we have a new law which is breaking ground. It's literally last week. So we'll have to see how the courts will implement that. But in principle, it can, of course, be enforced, either be it a foreign judgment or an award, only against the named debtor. But this award will exist. It will have res judicata effects, and therefore it cannot be ignored. And in certain situations, it might be opposed to a third party. And in this situation, there is also a possibility, which is not very much explored in the Luxembourg Case Law, to enforce it against an alter ego. Now, the alter ego doctrine is very much more established in other countries. Luxembourg many times relies on French law, not always. And we believe in certain conditions it could be applied, but the conditions are very strict, and they would have to be extremely well. So in a nutshell, this is what we can say about Luxembourg. Not very much case law. We dig into it quite a lot, but basically that's it. Thank you.
Thank you, Fabio. Despite the differences between our three jurisdictions, I think there is one takeaway on which we may agree, is that the parties should agree on a clause specific enough, referring to the arbitration. But I'm sure there are several questions in the room. Well, welcome to ask your questions.
Thank you very much. Dr. Mahmoud Hussein, I'm a practitioner lawyer from United Arab Emirates. I'm visiting the Paris Arbitration Week. And as well, I'm professor at UMSS in Dubai and in Eastern Area Norwich. I think for me, the best takeaway of this case is that the arbitrator or tribunal has a duty to lay up a forcible award. For me, it's a shocking to see a tribunal which has a people from the region, from the Eastern region, who knows that it's not this judgment with award, will not be enforced in any GCC country where Kuwait Food has assets. They will not hear course at all, because in our region, the court will come to the conclusion, or we are civil jurisdiction. However, the conclusion will be similar to the English force. However, not because of the applicable law, because of the look to Article 5 of the Convention, and they would believe there is a procedural public policy. And part of that domestic procedure, and not international, domestic procedural public policy is that you cannot extend the arbitration clause to no signatory party. So they would be refusing the enforcement. So I thought like the tribunal, wise and named tribunal, would have looked to that, because I would give you an example. Recently, we modified arbitral award, the international arbitral award, and the dispute was 20 million euro, and the cost for tribunal for consents was roughly 5 million euro. So 5 million euro, and it's a 20 million euro, and then the award was set aside. Set aside the award simply. So I think we have to as well question the credibility of the tribunal when they do not come from the same part of the world where this award would be enforced. Kout Food is a Kuwaiti company that SFE that in Saudi Arabia, UAE, Kuwait, all of the jurisdictions are simple that will not be extended. And the only jurisdiction in that part of the world recognize international public policy, or only not transnational public policy in our part of the world doesn't recognize, is the Lebanese law. So all of that part of the world, they don't have. They look to domestic procedure and public policy. So for me, the takeaway is the tribunal has to listen. And this is very important for us who sit at the tribunal to look beyond. The question is not English or French. It's a beyond that. It's a where the asset, where this award will be enforceable. And what party doesn't want a non-enforceable award? This is my takeaway from that. And I thank you very much. It's a very enlightening session.
Oh, thank you. Just to jump on what you just said, I think you sum it up, but the arbitral tribunal is in an impossible situation, because what if the award is set aside in France because they wrongly declined jurisdiction over Kout Food? Well, will it be enforceable in the Middle East if it's set aside at the seats? I think they are in a very, very complicated situation. In France, it would not be a problem. We enforce award set aside at the seat if we consider that they are enforceable. But it's not something all jurisdiction would do.
I would think a prudent tribunal would think setting aside and giving it to another venue, French court or Kuwaiti court, is much better and seem cost effective for the party. Because at the end of the day, we try to give a justice for the parties. We don't want them to enter 5 million euro because of their dispute with 20 million euro. So basically, we should look to that. And I think from my perspective, I think it's not justice. It's a prudent. If you say, I don't have a jurisdiction, I don't think the court would come and say, no, you have a jurisdiction. So basically, the tribunal has done it.
There is a question for that, then. Thank you. Luke Harrison. Sorry, to set a cat amongst the pigeons, if I may. Good friend of mine who's a PSL at DLA Pine Club in England brought to my attention just yesterday that the Law Commission, which is looking at the English Arbitration Act, previously declined to address the issue in, I think, paragraphs 11.8 to 11.8 to 11.12 of this consultation paper. But a couple of days ago, it announced that it is revisiting that decision, and the Law Commission is issuing a new consultation paper. So it looks like the issue will certainly be grappled with, so far as any new guise of the English Arbitration Act is concerned. How that helps in other jurisdictions, I don't know, but...
Yes, I did see that. I think it is very interesting the furore that Kout Food seems to have raised. From what I understand it, initially the Law Commission did look at this issue and decided that no change was necessary because anchor was sufficiently clear. But then if they're revisiting the issue, so they had to follow the Scottish approach and have a specific provision which says that law of the seat shall apply, or alternatively advocated enshrine anchor, or try to enshrine anchor into statutory form. Seems to me that's a very difficult thing to do, but that would be another approach. I think all I can say is watch this space.
Yes, I'm a better handle. I think that the difference between English law and French law goes beyond the applicable law. There is a fundamental difference of approach in the interpretation of an agreement. In France and in many, because the division is not between common law and civil law. For example, India follows the French approach, and you have Holland, Germany follow the English approach. So it's not a device, common law civil. So the basic problem is the way the two systems interpret an arbitration agreement. In France, in Belgium, many in Switzerland, we can take into consideration what happened before the conclusion of the agreement. We can take into consideration the conduct of the parties after the conclusion of the agreement. In England, it's not possible to take into consideration the pre-contractual negotiation except in really heated cases, as they refuse to take into consideration the conduct of the parties after the conclusion of the agreement. So this is a really fundamental, basic difference between the two systems.
Hi, this is Shreya Aaron from that was invented in London. I was going to add on what Luke said, and actually the Law Commission did release the second paper last night, and they have actually proposed that we change the position to what is the French position. They say the Scottish legal position is not clear enough because it says unless agreed otherwise, which could still mean that ENCA implied choice and express choice falls within the purview of that. So actually what they've suggested is that there should be a provision in the Arbitration Act 996 saying that the law of the arbitration agreement should be the law of the seat unless expressly stated in the arbitration agreement otherwise. So that's the provisional proposal they've set forth, and they've asked for stakeholders to respond to that. Breaking news as of last night.
Very interesting. Thanks very much. I think, yeah, I know one thing I can say about that, it's an approach. It's a potential approach. I think all of the approaches possible to have pros and cons. And I think the difficulty about specifying that it's the law of the seat that applies in all circumstances is that you can have the problem of, what's sometimes called the shipwrecked arbitration clause, where you have an arbitration clause that actually has different parties to it from the rest of the contract. So you have an arbitration against a party, and that party doesn't have any contractual substantive rights that are binding on it. It's a difficulty.
Well, and just one word, I think it's interesting because it comes closer to the French position, but just one slight thing I would like to add to your comments is that it's not the French position in Kout Food. The French position is not to apply the law of the seat, is to apply the substantive rules of international arbitration wherever the seat is. Just to be very clear about that, which is, I know, very disturbing for lots of our English friends.
Sorry, I already took the mic. I've Pratyush from Harity and Vandenberg. And just to take further what Professor Harity already said, in terms of interpreting arbitration agreements and contracts containing arbitration agreements, especially English law, is there I'm not sure how the court examined the existence of other agreements that were also at play in the Kabab-Ji case side. I recall there were other franchisee agreements, there was some memorandum of understanding as well, over and above the agreement which did contain the arbitration clause. I know that the Parisian courts, I think, took those agreements into account while extending the arbitration agreement, so to say. Is there any insight on how the English courts would react to that, and whether they'd look at consent from a more adaptive and practical standpoint as opposed to a strict standpoint of looking at the agreement itself?
I think the answer must be yes. I think the English courts are always trying to ascertain what the intention of the parties was. And if there are agreements that are relevant to that, then yes, they will look at them. As I understand it, in the Kout Foods case, there were several distribution agreements, but they're all governed by the same, or they'll contain the same arbitration clause. So I think they didn't change the position. I think one thing that was interesting is the point that was raised by Marianne, and that is that this was an agreement where there was a specific clause that stated, well, first of all, it defined the agreement, as being all of the terms of the agreement. And then the governing law clause said that the agreement, i.e. the agreement defined as including all of its terms, shall be governed by English law. And that's reinforced the Supreme Court's view in that case. But I think what that does show is that the court will look at the terms of the agreement, anything associated, and apply the usual tests for contract interpretation when they're considering this question.
Yes, I would like to, Charles, welcome to follow on from comments made by Luke and also set caps amongst pigeons and the like. We looking at the English position as far as consent of the parties to an arbitration. It seems to me that the English are actually very much on an extreme, very unwilling and reluctant to allow in related parties. And actually, if I'm not mistaken, other common law jurisdictions, India in particular, does have a much more flexible approach, which to my is actually sensible, reasonable, and more in keeping, if you like, with the sort of pragmatic English approach that we supposedly pride ourselves on, but apparently in this particular field have a tendency to forget.
I suppose what I could add to that, I don't disagree, but I think the English courts do also focus on the idea that arbitration is, if you like, an exception from court jurisdiction. So you do need to be sure that the parties concerned have agreed to take themselves out of the court jurisdiction and to accept an arbitral jurisdiction. I suppose that's perhaps what's behind that feeling.
Thank you, Stan. Fabio raised two principles which seems quite practical. So the principle of agency and the principle of alter ego. If I remember correctly, some European countries don't recognize at all the principle of alter ego. As an example, I will name Belgium. The alter ego principle is not recognized at all in Belgium. But my question is regarding England law. Of course, there is a principle of alter ego, but it seems that the criteria are very restricted in comparison, for example, of the criteria applied in French law. And maybe this is one illustration of the main differences of the two case law in England and in Paris. What do you think about the criteria of alter ego according to English law?
Yes, I mean, it is very restrictive. There's an interesting recent case, the case of Brest, where essentially there was an application where it has the culprit fail, and the court was very restrictive, as you say, as to when that can happen. Essentially, it's when the company is being used or misused to get around a legal right or obligation. So it's essentially in cases of fraud or things akin to fraud where that principle can apply in English law. I don't know, Fabio, if you have anything you'd like to add into Luxembourg law.
Not much. In Luxembourg law, there's not much. I think there's only one decision. It's very, very, very unheard of. I think that the courts would look at what happened in France, where there is a much more developed case law, and that's what we'll see. There are a few cases which are actually being disputed, so I think shortly we'll have some answers.
One last question.
I have a question. I have a question to Fabio, colleague in the Luxembourg bar. Don't think the Luxembourg Court of Appeal usually refers to the principle of pacta sunt servanda. The law of the contract is what applies to the parties. Very non-interventionist. That's what I've seen. I'm not done as many people, but I certainly have done a few cases which have gone up to the Cour de cassation. And my impression always has been that there's a certain strangely, there's a certain alignment with the English law approach of the where we just look to the contract and the judges will not look too far to interpret. What is your view on this?
Yes, very pragmatic approach. I agree, and that's exactly what they said. When we initially looked at this case, we would have said, of course, the English approach would prevail in Luxembourg. But I think there is some evolution. I think that these decisions, that I spoke about, do speak about the autonomy of the arbitration costs. And that went in the direction of when now the new law now enshrines in the law this principle. So I think we have a real change of the landscape, complete new grounds. And of course, it's going to be seen how they would interpret that specific article. But I believe that this law, which was very much discussed among the community, went into exactly that direction. We looked at what France was doing. We looked at the favor arbitrandi. We clearly wanted to create a favorable environment. And that's what the legislator agreed with, to create in Luxembourg a place of arbitration, which for now we cannot say it really is. And we think that this new law would bring us to what hopefully one day, I don't know when, Paris is seen as the most favorable place for arbitration. That's our model.
Well, thank you very much for your attention. I would like to thank Violet, Natasha, Marie-Hélène, and Fabio, which have been very good speakers. I think they deserve a strong applause for...